Okay, Ms. Bauer, are you on this?
No, Your Honor.
This is the opening hook, so I stretch it to 1-2 minutes. The case launches with confusion over who is even on record. Already you can feel the tension, clerical errors, missing filings, and immediate questions about escrow payments. This isn't small talk, it's the foundation of a legal storm. Judge Simpson wastes no time probing inconsistencies. From the start, the defendant's position looks shaky, claims of technical assistance and excuses for late filings. Here's what makes it dramatic. In eviction or termination cases, procedural compliance is life or death. Miss a deadline or escrow, and you lose standing. That's why Simpson zeroes in, because if escrow isn't paid, the case can collapse before it begins. And think about it, if you were in the defendant's shoes, would you risk everything on a technical delay, or fight tooth and nail to prove compliance? This early moment sets up the battle lines.
Well, okay, I just need you to know that the answer to the complaint has you listed as the defendant's
I
attorney.
was just providing technical assistance to minutes. This murder, I just said in the email that I was assisting her in getting it filed, but I didn't appear on the case.
Okay, all right. What are we doing? Your name? Your name? All right. Where are we on this?
This Silver did not pay her escrow. She was ordered to answer, I think she got her answer in nominally on time, but she did not pay her escrow.
Yes, I did. I can't deny the other 550. It was going to be given to me, but it was not. And so I do agree with that.
550 was paid on April 3rd, according to our records.
Notice how precise numbers come into play. Courts love documentation, and here, the defendant insists money was paid. But Judge Simpson highlights the missing balance. This is where landlord-tenant disputes often unravel. Partial payments, undocumented transfers, or the other manager was supposed to handle it. The excuse of blaming the other guy is risky. Courts demand responsibility, not finger-pointing. The energy here feels almost like a chess game. The defense tries to delay or muddy facts, but the judge stays locked on one issue: escrow compliance. Without it, defenses crumble. Ask yourself, if someone blamed another manager for handling your rent, would you buy it, or would you demand proof in black and white?
Order was for 1,100.
Yes. Where's the balance of that, man?
Balance of 550. I was, to be honest, the other occupant and stuff was supposed to have given it. He did not, and I cannot come up with the money my own self. So I paid my I'm not going to deny.
Yeah, they're in advice to the other occupants unauthorized. So that's part of the reason. But determination is that you've got unauthorized occupants in the unit without permission of the landlord. And it's a violation of release.
The answer is late also, but
Late filings plus late escrow equals double trouble. Simpson makes it clear he's debating whether to strike the answer entirely. That's nuclear. If he strikes, the defendant has no defense left and the landlord wins possession almost instantly. The tension spikes. This isn't about personalities, it's about procedure and strict deadlines. What's fascinating is how the law balances fairness with efficiency. If courts allowed endless delays, cases would drag for years. That's why the deadlines matter. They're the backbone of justice. But here's the dramatic kicker. Simpson still entertains trial. He wants the facts on record, even while pointing out procedural failures.
this is a termination of tenancy case. Is that correct? Well, you haven't complied with the escrow order, and the answer was late. I'm looking at it, deciding whether or not I should strike the answer. But in any event, plaintiff is entitled to an immediate trial on the issue of possession. So are you prepared and ready to go to trial, ma'am? Pardon? You are? Okay. You have your client here or? Okay. The basis for the termination.
Basic determination was damage caused by the unauthorized occupant flooded the house, causing several $100 of damage, just a little bit more if he had done a lot of work himself.
Now the stakes explode, flood damage, collapsed ceiling, hundreds in costs. Suddenly, this isn't just a rent dispute. We're talking property destruction. The landlord's case shifts from paperwork to tangible harm. Simpson carefully draws out the narrative. Was this intentional, negligent, or just bad luck? Notice the defense response. Talk to the other guy, he's responsible. Again, deflection. Courts rarely accept it wasn't me without receipts. Think of it like this. If you lease a car and your friend crashes it, you're still liable. Housing works the same way. Tenants bear responsibility for what happens inside. This is a turning point. The narrative changes from missed escrow to flood damage with disputed responsibility. Would you side with the tenant blaming someone else or the landlord footing the repair bills?
But they caused a flood above him, which caused the ceiling to collapse. They denied responsibility for it. Well, actually, what she said is talk to the other guy, the unauthorized occupant, he's responsible for it. The damage to the premises, two unauthorized occupants living with her, violation of the lease. Frankly, I don't think she's already admitted that the other occupant didn't pay his supposed debt, escrow. So her own admissions are that she's got somebody else there who's a violation of the lease. I don't frankly think there's a threat.
And what's your position, Ms. Stoneman?
Yes, sir. Yes, Your Honor. We signed a lease back in October with Mr. Palmer, with Chad from CMH that paid the amount and a security deposit, which Mr. Kevin Salisbury is on that. When me and Kevin Salisbury had an argument, Your Honor, I went to my
Now the story thickens with lease confusion. The defendant claims the landlord ripped up the old lease and drafted a new one without properly evicting the prior co-tenant. Judge Simpson's ears perk up. Lease law is crystal. You can't just tear up contracts on a whim. The defendant admits guilt but insists the original lease still takes place. This contradiction is devastating. On one hand, she admits a new lease was made. On the other, she argues the old one survives. That's like saying both can exist at once. Impossible. Simpson zones in "Do I have a copy?" and the defendant fumbles, "No written proof." This is courtroom gold. Allegations without documents collapse under judicial scrutiny. Question for the audience. Who do you think benefits more from missing paperwork? Landlords or tenants?
my landlord, he ripped it up in front of me, the original one.
The
And
original one,
the original lease. And then we made up a new lease, which also he did not give permission to Mr. Kevin Salisbury that he was terminated. He never evicted Mr. Salisbury from the tenancy. He just ripped up the lease and had me do a new lease without consulting Mr. Kevin Salisbury about it. So that original lease should still take place, and I am also guilty with Mr.
well, do I have a copy of that alleged?
The first lease?
Yeah,
Yes, I said they're giving it back to Mr. Palmer, which he knew this. And,
well, but do I have a copy of it?
No, I don't think so. Because Mr. Shad said he didn't have enough accredited time from CMH that he does have a copy of the original lease with Kevin Salisbury on it, I'm on it. And there was a verbal agreement with Mr. Palmer, knowing that my 15-year-old daughter worked very hard for 3 years to get sole custody of her, and he knew this. And he said we didn't have to add her because she was a 15-year-old. And
What happened with the damage to the premise?
that, sir, he called me on my phone and I was at work.
He who?
Mr. Palmer called me. And he said there's water going upstairs. I said, well, I'm at work. Knowing that he's a landlord with a key, if he knew there was probable damage, sir, that the defective water was running, he has permission to go into my apartment with his key to go check on that damage. I have never heard of this after that. Nothing. I've never seen a bill, never seen anything. I I paid my security deposit, so if he had out of pocket expenses, sir, he should have used my security deposit.
She can't do that. So why'd you sign this other lease?
Out of anger. As I went back to Mr. Palmer and I told him there, and he had no problem. Maybe I should have talked to him under different circumstances, Your Honor. With Mr. Palmer, sometimes it's not. I will not say this, I will not require her, but Your Honor, my thing is if he had damages, I wish he would have shown me proof. But he did have access to my apartment. No, he had a key to.
This is the credibility test moment. The tenant claims the landlord had keys, could have entered to mitigate damages, and never showed proof of expenses. On the surface, it sounds like a reasonable defense. If you had costs, show me receipts. But courts don't always see it that way. Landlords argue that tenants can't shift responsibility just because access existed. Simpson spots the gap. Whether or not the landlord could have acted sooner doesn't erase the flooding. This is where the drama feels almost cinematic. The defendant frames herself as powerless, while the landlord paints her as negligent. And Simpson, he stays surgical. He wants evidence, not excuses. If you were the judge, would you hold the landlord responsible for not intervening, or the tenant for the damages themselves?
I mean, you're not claiming that there aren't damages.
I don't know if there is, or he never gave no proof.
Who is it you say has this other lease?
I mean, Mr. Palmer. That's who I handed it to.
But you said somebody else has another copy?
Shad for CMH, yes, sir. And he didn't have an adequate enough time, and I've also.
What do you mean he didn't have adequate enough time?
When I went and talked to him about it, he said it's gonna take time to fill out everything, and he knew that I had court today. And I put that in my written statement. I also stated that, I asked for, for him to give me proof. If he can give me proof that there was damages and that he did work on the floor, that it was flooded, he should have some kind of record of the cost of that. So if he did have that cost, he needed to take it up.
So is this other individual residing in the premises?
Yes, he is. And he is willing, I think he's gonna make his own motion with Mr. Palmer.
His own what?
He's gonna be taking Mr. Palmer himself to court. Off late trying to whatever, because he still legally should be able to be there with the lease that his grandmother has or whatever he's trying to find. And my daughter, sir, she's 15 years old, Mr. Palmer. And I'm not saying this, but normally, I mean, my daddy always said handshake is better than. And I did trust Mr. Palmer's word, and he trusted mine. And I'm guilty of, some things myself. I'm not saying that.
Was there another lease, Mr. Friedman?
In other words, Your Honor, the lease that's in place is the lease with her alone, one occupant, her. They had no other occupants are authorized.
So I guess my question is a little bit more specific than that. What I hear the defendant indicating is that there was a lease that included two people. That somehow what she's basically claiming is that impermissibly that lease was terminated and this lease signed. Is that correct? Do you know?
Yes, it was.
Do I have a copy of that other lease?
It was destroyed. It was destroyed.
Yeah.
Shocking moment. The landlord admits the original lease was destroyed, literally torn up. This hits like a bombshell. Lease termination requires notice, not scissors. By destroying the contract, the landlord may have invalidated both leases, creating a legal limbo. Simpson immediately calls it out. That would not be a proper way to terminate the lease. Exactly. Law thrives on formal process. Tear up a lease, and you don't erase obligations. You create confusion. This scene illustrates why paperwork is sacred in real estate law. No matter the emotions, breakups, car thefts, personal drama, the legal document rules. And Simpson makes clear this termination method could tank the landlord's entire case.
Under what basis then was that lease terminated and this new one put in place?
When the man in question took her car and towed it. I mean, I didn't see him. She said, I don't want him here. He's here, he's trespassing. Is there any way you could rewrite something so he cannot be here? So I said, are you sure? I said, give me the only sole copy of that lease. And I destroyed it. I shredded it. Put the lease for her, so she wouldn't have to worry about this person bothering her. And then he shows up right before the holiday and said, oh, he's my guest for the holidays, starting before Christmas and continuing until today. I mean, still there. And then 3 weeks ago.
All right, well, how long, that would not be a proper way, just on the face of it, to terminate the lease, the previous lease, and then enter into this next agreement
He had left.
and then seek to evict her for what may have been that prior agreement. I mean, there,
Well,
go ahead, Mr. Crittenden.
he left and he had.
I don't-
And so, and basically, I mean, and she's saying, I don't want him around. He's destroying my car. He's left. I don't want him around. I want a new lease. So he does, you know.
But the question is how was his interest in the property as a tenant terminated? I mean, we get into a very strange world if leases can be terminated by somebody tearing up the lease.
So he did abandon the premises.
Do you agree with that, ma'am, that he abandoned?
He did leave because he was in the hospital, Your Honor. He did told my vehicle. He was in the hospital for a week. He definitely came back, and that's when Mr. Palmer called me about the water. Your Honor. During that time, he already knew Mr. Salisbury was staying there. He knew this. How come he knew about that in October?
Okay, so how long did this gentleman leave for?
About 5 days in the hospital, and I think that's.
Well, okay, so hold on. You and this other gentleman are in some type of relationship, would that be the case? And so as I hear it, Mr. Palmer, something happens as a part of their relationship. She tells you, and then you tear up the other agreement and enter into this new agreement.
This is Simpson's brilliance. He reframes the whole situation. The landlord acted out of personal sympathy, ripping the lease to protect the tenant from her partner. But legally, that move is chaos. Think about the irony, trying to help the tenant actually undermine the landlord's claim to evict her. This highlights a key lesson. Courts don't deal in good intentions, they deal in procedure. You can hear the judge almost mocking the logic. How many times have you heard someone say they don't want their partner around? Relationships flip fast, but leases don't. This commentary moment exposes how emotional decisions collide with rigid legal frameworks. And here's the real suspense. By pointing out the improper termination, Simpson signals the defense may have a real shot. That twist keeps viewers glued.
Is that,
Yes, she said he was gone. She didn't want anything to do with him, doesn't want him there because he's trespassing. So to save her from, I don't know what kind of trouble, she said he's not coming back. She said, no, I don't want anything to do with him. I'm done. Done. So I said, well,
okay, so how many times have you heard that in a relationship? I mean,
I don't,
I mean,
I'm sorry, I just don't deal with it. I'm just waiting.
I know, I'm just saying,
I just,
I mean, on behalf, all parties, at some point, will tell anybody else, I don't want somebody there. I mean,
he was physically gone. He'd taken her car. He totaled her car. He was in the hospital for 5 days. The day he came back was the day she left, I guess. And when he turned the shower on, I don't know, it was running for an hour at least. I'm banging on the door, banging on the ceiling. I knew somebody was in there, so I didn't want to go just walking in there. As she said that I had keys to enter the property. I didn't.
which you do.
Yes, but I didn't want to just go walking in there. I'm banging on the door. Somebody was physically in there. I didn't know what was going on. I couldn't turn the water off on my half, so.
Yes.
So then. I'm not even clear what to do with this because I've got this other lease. that sounds to me like it's not properly terminated.
Doesn't exist. Well,
Well,
Your Honor, it seems to me though that the only person that would have any standing to raise that issue would be the dude, whatever. And he's not here.
well, no, the defendant has standing to raise the issue because if part of the reason you're terminating her or the basis of the termination is that she has this unauthorized occupant. And then two unauthorized occupants, who's the other one? Oh, for,
He's 15, and we did do a verbal agreement with Mr. Palmer when I did it.
how old's your daughter?
She's 15.
So you're claiming that's an unauthorized occupant?
The case takes another twist. The tenant's 15-year-old daughter becomes a factor. The landlord argues she's an unauthorized occupant, but Simpson slams the brakes. His words drip with moral weight. Am I supposed to tell her, you fought for custody, but now you'll be homeless? This is human drama in pure form. Simpson blends law with empathy, recognizing that rigid enforcement could punish a parent for regaining custody. The courtroom shifts tone here. It's no longer about escrow or floods. It's about family. This is why judges matter. They interpret the law with humanity. For the audience, the tension peaks. Should the law flex for family rights or hold the lease rigidly? Comment below, would you evict a tenant over their own child?
She didn't have the daughter when she signed the lease. She wasn't custody.
And now you have custody.
Yes, so after 3 years, I got custody. Mr. Palmer knew it.
So what am I to do with this daughter?
Well,
I mean, am I supposed to tell her her mother, oh yeah, you fought for custody of your daughter, but she can't stay there with you and your lease is being terminated. So I'm now, because you fought for custody of your daughter, you're now going to be homeless. Is that what I mean, is that the position that plaintiff is taking?
that's not the position plaintiff's taking. We're saying is that when you add it all up, there was supposed to be one occupant, now there's three.
Well, no, because Miss Salisbury, the other lease, there were two occupants. And so so maybe there's three now. And then I'd have to figure out what to do with, I guess, this newfound daughter. And then
There's another 800-pound gorilla in the room, which is there hasn't been any rent paid since January.
They charged for rent in January, 811.50, and there hasn't been any payment for February to March, which is the tune of $4,400.
go ahead.
With the damages and stuff, also that he's trying to terminate my original termination. Is he never forthcome when he called me, I was at work, he talked to me about the water.
Now the landlord pivots back to hard numbers. $4,400 in damages, unpaid rent, escalation of claims. Simpson isn't impressed. He's still stuck on lease validity. Notice the clash. The landlord pushes financial losses, but the judge keeps circling back to legal process. Without a valid lease termination, damages claims weaken. This is a critical courtroom strategy lesson. You can't win on damages if your foundation is shaky. It's like suing someone for breach of a contract that doesn't exist. For viewers, this is a masterclass in judicial priorities. Judges don't get swept up by dollar figures until the underlying structure is sound. It's less about sympathy, more about logic. Would you side with the landlord counting costs, or with Simpson drilling the contract floor?
I said, Mr. Palmer, I'm sorry, I am at work. And he says, okay, I called back again within a couple of hours and it was off Tennessee. And that is the last time I heard from Mr. Palmer on the issue of any damages. Never seen a piece of paper, never seen any damages.
Do I have anything about the damages, since everybody wants to go there? I mean, I'm still stuck on this lease thing. Does she have a copy? Go ahead, take a look at it, ma'am.
I did not think this is the first time I've ever seen.
No, I know, but take a look at it. Do you have any objection to the court seeing that?
No, let me see.
Well, hold on. Do you have any objection to me looking at it? Because I don't know what you start talking and I don't know what you're talking about. Okay, so. Who's this from?
A contractor?
Okay, does the contractor,
That?
does the contractor have a name?
Yes, Jeremy.
We have the photos of damage. Let's see.
No, I understand that, but
Rather may I speak one more time?
no, not right now. Sometimes it's better not when you're ahead. So. It's $625.
Now comes the receipt showdown. The landlord claims payment for repairs, but the documentation is thin. No contractor name, no photos tied clearly to the tenant's actions. Simpson zeroes in vague receipts won't cut it. This is a classic moment where evidence decides everything. Courts don't rule on feelings or half-proofs. They want airtight documentation. The tension here lies in credibility. Is the landlord padding numbers or genuinely showing costs? And the defendant smartly challenges, I've never seen a bill, never seen anything. This flips the pressure back. If you're a viewer, ask yourself who looks more credible here, the landlord with incomplete receipts or the tenant demanding hard proof?
Yes, sir.
Okay, but have you paid this?
Yes, I have.
Is there a receipt for the payment?
I didn't get one from him, but I just paid him cash, gave you that as a receipt. As it says there, paid final amount.
By somebody who it doesn't.
If you see the pictures, you'll see the 625 as a bargain.
Okay, I don't. Here's the problem that I see. First thing is this other lease. Because I don't know if this other lease is the same as this lease, but just the names change, or if there's something different in it. I don't know that. That's the first thing. Second thing is I am still unclear as to how he, in essence, terminated a tenancy by tearing a document. Because the reality of what he did would not only be to terminate the tenancy of the other individual, it actually terminated her tenancy, and then she enters into a new tenancy, supposedly. But I don't know that that first tenancy was properly terminated. If it's not properly terminated, there's at least an argument that this lease that you're seeking to terminate her is void or voidable, and that other lease is the one that applies.
This is the legal bombshell. Simpson openly questions whether the entire lease is void due to improper termination. That's huge. If void, the landlord's case collapses, no eviction, no damages, nothing. Notice his careful phrasing, void or voidable. This distinction matters. Void means never legally existed. Voidable means defective but fixable. Either way, the landlord's footing is weak. This is why courtroom drama hooks audiences in one sentence. The judge flips the balance of power. Imagine thinking you're minutes away from eviction, only to hear the judge undercut the landlord's claim entirely. This is suspense television, except it's real. Do you think Simpson is leaning toward mercy for the tenant, or simply exposing sloppy landlord tactics?
All right, that's my just initial thought on this.
Certain hand.
Go for it.
I thought.
I don't know why you were involved in their relationship. So go ahead and you tell me what you want to tell me.
I was not at all. I thought, by the way things have went for her, and she was coming to me and saying, hey, I don't want him here. Basically scared of him. I don't know what the situation was. If he's here, he's trespassing. Can we do this? Her and I stood there, and that's what we agreed to do the new lease.
I wonder if I could have done that with my mortgage company in Maxwell. Could I? I mean, I'm just asking. I mean, if stuff works that way. Alan? Okay, all right, I'm just checking.
I think this is the thing where he thought he was doing her a favor and.
I know, but, and I get that, Good Samaritan and all that wonderful stuff. But then I'm now here, and because this guy came back that she may have been mad at him for a while. They patch their differences. I don't know, her car gets repaired, whatever. And then because she does that, and because there's this damage, I get the damage part, but because she does that, the one basis upon which now she's being terminated, it seems, is because she repaired her relationship and also is being terminated, I guess, because she was successful in fighting for custody of her daughter.
Simpson lands a devastating critique. The tenant is being punished not just for alleged damages, but for reconciling with her partner and for regaining custody of her daughter. Think about that. The very acts of repairing family ties and asserting parental rights are being weaponized against her in eviction. Simpson calls it out as absurd, almost sarcastically. This is a beautiful scenario. This isn't just legal analysis, it's social commentary. Judges rarely reveal bias, but here, Simpson's tone is biting. He highlights how rigid landlord enforcement can clash with human realities. For viewers, it's a moment to pause. Is the law protecting property or punishing people for personal lives? Would you interpret Simpson as defending the tenant or simply spotlighting unfair optics?
This is a beautiful scenario.
Well, we didn't raise the daughter issue, but it's.
Well, no, he did. I mean, so let me ask this, Mr. Friedman. Is part of the basis for this other person her daughter? Part of the basis is that she has unauthorized occupants. Is your client claiming that the daughter, the minor child?
We can mention the daughter.
Okay, so is that an issue?
We're not raising it. It's a fact.
Well, he
It's a
did.
fact.
Okay, but when I said there's an unauthorized occupant, somebody said two. And so one of those would be her daughter. So what I'm asking is part of the claim in this case, the daughter in the premises?
No. It's a fact, but it's not, we wouldn't have terminated the tenancy because of that. No, we terminated.
Okay, so I don't have to worry about the daughter.
No.
Okay,
But we do.
I just have to worry about this guy that she got mad at, that all of a sudden the lease gets torn up, that then they repair their relationship and now he's an unauthorized occupant. That's the only one I have to worry about.
And the fact that he caused the damage, yes.
Okay, I mean, we can get to the damage part, but and what?
They haven't paid rent since January.
Okay, but I've got a termination case.
I
in front of me.
understand, but you're gonna have, it's a 7-day case in 8 days.
Okay, so, ma'am, the individual that has a copy of this initial lease, how long did they say that would take them to get?
Which I will make comments tomorrow and we'll figure it out. I did propose to Mr. Palmer through Ms. Jill, that I would like to be out by May 31st. I'm willing to give the security deposit by 50, and I'm also willing to pay the first month's rent in May by the 1st of $1,100. I would like to be out by May 31st.
So you want to pay $1,100. He keeps the security deposit, you don't have any claim over it, and you just want to be there till May 31st. Well, hold on. Yeah, there could be an immediate trial. However, I've started a trial, I guess, but I've got an issue because of this other lease. So, and it's not here because your client says it's destroyed. She says there's a copy that exists, but she can't get access it at this point. She's going to try to access it today. So it would seem to me that I would adjourn this in any event.
I understand. This is my first trial. My first time.
I know. Yeah, I know. You can see where it's going.
But I would say this, if I was inclined to make that suggestion, I would want a COD because.
And I think that could be in a COD. She seems very definite that she's going to do these things and then leave. I don't think your client likes the idea. So why don't I just adjourn the trial? And my next date isn't until like late April anyway. Huh?
April 22nd.
So it would be April 22nd. We'd have a trial. I don't know. I don't know how long it would last. We might get till the end of May in any event. But I mean, if that's her proposal, it seems like a reasonable one. She doesn't want to stay. And by the way, the other thing that's faced is that if I find that the lease here is void and or voidable, you're going to lose anyway. Once I see that second lease. Or at least there's the potential. So here's what I'll do. You're going to get a copy of that other lease. I'll adjourn the non-jury trial to April 22nd, 2025 at 9 a.m. And something we've learned today. If your lovely wife starts yelling at you, just give her a notice to quit. All right.
I do want to do the request for escrow. Give it back.
I understand, and that would be my next available date for a trial. So you're entitled to an immediate trial, and she's gonna pay her escrow. Bye. I guess she's leaving. Okay. All right. Thank you. No, really. I hear you. Just tear it up.
This closing quip from Simpson shows his sharp wit, but beneath the humor is a serious ruling. He adjourns the trial, sets a new date, and orders the other lease to surface. The eviction stalls. The defendant buys time and the landlord faces the burden of proof. The drama leaves us on a cliffhanger. Will the missing lease resurface and destroy the landlord's case? Or will the receipts and damages finally hold up in court? Either way, Simpson reminds us that eviction isn't just about late rent or broken plumbing, it's about contracts, evidence, and human lives. And here's where I leave you. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.